All right, everyone. Good morning. Okay, it is Tuesday. It can't be that bad of a week. Good morning, everyone. Good morning. As I always tell people, happy Tuesday. It's going to be a great Tuesday. You all are here for duty. And I know that everyone loves serving the country. And one of the ways that you can do that is by being present for a jury. The United States has changed in a lot of ways. One of the ways that we changed is we used to have a draft. So we no longer have a draft. So one of the few things the country asks of you is for jury duty. I tell everyone what people say may be the greatest jury system in the world, or the judicial system in the world, if we don't have jury. Having great jury trials is having jurors to be present. I'm Stephanie Boyd. I'm the judge of the 187 District Court. This is a criminal court, and I'm going to allow both parties to introduce themselves. For the state,
Michelle Hayden. Good morning. Allie Jackson.
And for the defense,
My client, Jeremy ROTHENAY.
does anyone recognize any of those parties? All right, so the next thing I want to tell you is you have in your possession is something that is extremely expensive. It's those cards with the numbers on them. So anytime someone asks you a question, or if there's something that you want to answer, raise those cards. So let's test that out for a little bit. So can everybody raise your card? Awesome. Raise your card. Make sure that the number is facing towards both parties so that they can see you and announce your name for the record. She's the court reporter. Her job is to take down everything that everyone is saying. She's one of the best court reporters. I say that because I've seen her take down 3 and 2 people speaking at. But it's a Tuesday, so let's make it a great Tuesday for her. And only one person speaks at one time, because that will make it easier for her. The other thing, and I'm hoping this will be the jury panel that follows these instructions. If you are sitting in what's called the jury box, if you're on the front row here, when you have something to say, you don't have to stand, because everyone will be able to hear you. Anybody who's not 3 rows, anytime you want to say something, if you can, we're going to need you to stand, and everyone make sure that you speak up so that everyone can hear what you have to say. All right, as you can see, the charge in this case is indecency with a child by contact. I'm going to come back to that in a moment, but I just want everyone to be thinking about that. Now, how does someone get to a court? They're charged by indictment. Just because you're indicted, that is no evidence of your guilt. An indictment is just the means by which someone is brought to court, so they'll know what they're charged with, what they're being accused of, and when they need to appear. Example I like to give. Has anyone in here ever had a traffic ticket? Okay, see, people, raise your card, raise your cards. At one point, I could say that I never had a traffic ticket, but on my way back home to see my mom, I got a traffic ticket. So when you get a traffic ticket and you're pulled over, when it happened to me, I'm from old school days, they would write you out a ticket. They had the little ticket book. Now I think they do everything. When they give you that ticket, they'll tell you court or wherever it is you need to appear and what they're charging you with. When you accept that ticket, you're not admitting your guilt. You're not saying you're guilty. It's just the officer saying, I'm saying you were speeding. That's why I pulled you over. I'm saying you didn't wear your seatbelt. That's why I pulled you over. Then you get to go to court once you know what you're charged with, and you get to have your trial. So it doesn't necessarily mean that you were speeding or guilty of whatever traffic ticket. It's just to give you information for what you're charged with and where you need to appear. Does everyone understand? there anyone here who will hold it against Mr. ROTHENAY just because he has been indicted? Okay. Now, how many of you have watched all of the legal shows? Who has not seen a legal show? Now, mind you, the legal shows I'm talking about are Barnaby Jones, Marcus Webb, Quincy MD. So anyway, has everyone heard of the right to remain silent? Again, I'm testing you with the cards. So every accused of an offense has the right to remain silent. You don't have to say anything. The fact that someone remains silent, you can't take that sense of guilt. You can't take it for anything. Does everybody understand? Yes. Now, sometimes when you have a jury trial, people will always wonder, well, I wonder what the defendant would have said. Or I wonder what this person would have said. It's okay to wonder, but you cannot hold it against someone if testify, and you cannot use it against them, and you cannot convict anything. Does everyone understand? Who would hold it against Mr. ROTHENAY if he decided to? That's number 63. All right, just one moment. All right, and here's the thing, before people, telling you again, jury duty is the only thing your country is asking of you. So these questions that I'm asking of you, you need to answers and not just maybe, I'm not really in. So how many people would hold it against Mr. ROTHENAY if he decided not to testify? That's number 8, 23, 29, 30, 38, 39, 47.
Judge 61 and 57.
All right, thank you. 61 and 57. All right, so everyone is presumed to be innocent. The state has a burden of proof. So everyone, when they walk into a courtroom, they're presumed to be innocent. That a defendant or someone who's accused does not have to prove anything. Does everybody understand? It is up to the state, and the state has the obligation and duty to prove someone guilty beyond a reasonable doubt. And that's the burden of proof in criminal cases. That burden never shifts to the defendant. Understand? Now, when I was in law school, we had to remember the definition of proof beyond a reasonable doubt. Guess what happened after I memorized that back and forth? Had my first trial as a defense attorney. And then guess what? The next jury trial I had, they changed the rules and changed the law. There is no definition of proof beyond a reasonable doubt. How people always explain it to everybody is by telling them what it's not. You're in a criminal case. You're not in a civil case. In some civil cases, for example, if you seek to terminate your parental rights, the burden of proof is clear and convincing evidence. Proof beyond a reasonable doubt is the highest burden. Does everyone understand? Now, there are 2 phases to a jury trial. Is what's called the phase, people call it the innocence phase, but really what it is guilty or not guilty. First phase, and this is how Texas is. If a person is found not guilty, then the trial has come to an end. If the person, then there's a second phase, which is called the punishment phase. In Texas, it is the law that the person who must make a decision on whether or not, if they were found guilty, the court for punishment, which will be the judge, or go to the jury for punishment. The selection of whether to go to the court or jury for punishment in no way is an evidence of guilt. It's just the law says, who's accused, you have to make a selection or an election. Everyone understand? In this ROTHENAY, if he were to be found guilty, he has chose to come to the court. So what that would mean, if he's found guilty, the court or the person who would be in charge of punishment. Does everyone understand? Now, is there anyone who's going to hold it against Mr. Roth? He were found guilty. He has made the choice for punishment. (16, 47, and 7). All right, next I want to talk to you about what's called the state and the defense. When they start their jury selection process, they are not to you about this case. They're both going to be speaking in hypothetical. Learn any facts of this case until you're actually on the jury. Does everyone understand? So this is that people usually give, and it's called the one witness rule. Rule is that the state has elements they have to prove. Hypothetically, they call one witness. Witness testifies, and that one witness through testimony proves every element. That one witness proves beyond a reasonable doubt. Is everyone with me on the hypothetical? You believe that one witness. There is no issue for you with regards to their credibility. Does everyone understand the hypothetical so far? So usually they will ask you after that is, will you be able to convict? Not in this specific case, but just in a hypothetical case, one testifies. You believe that witness. There's no issue with credibility. Sometimes when this hypothetical is given, people will say, yeah, but I need to know A, B, and C. So that means you have an issue with the witness's testimony. What I'm asking you is, you have no issue with that one witness. There's no issue with that witness's credibility, so you believe, and that one witness proves the state's case beyond a reasonable doubt. Is there anyone who would have issues with convicting? All right, that's 21, 57, 58, and 74. Now, the other question, and mind you, we've had this happen. I think people who speak a lot of language, whenever I travel overseas and I hear 3 and 4 languages, I think it's great. I'm not pick back up my French until I go overseas and I'm around people who are speaking French. But sometimes people say that English is their second language and they have. And is there anyone here who English is your having trouble following along with what's being said so far? Okay, that's number 75. Now, just meeting downstairs for the first time, is there anyone who knows someone else on this jury panel other than just downstairs for the first time? Okay, usually we get on a panel with a student. One time we had a wife and an ex-wife. So this is strange that nobody knows anyone. All right, so does anyone have any time constraints? And by time constraints, I mean that you have a trip, it's non-refundable. You can't say, Judge, I was supposed to go to Europe, but I'm in trial with you, so I'm gonna give you the ticket. See, I'm seeing if you got attention. So is there anyone who has some sort of time constraints? That. Okay, we have 13, 24, 32, 38, 46, 47, 74, and 75, and number 10. Now, if you're, 53. Some people, your time constraints are, I have children that I need to drop off for school, I have children that I need to pick up from school. Court will make arrangements for that. So out of those people who raised your cards, is there anyone where your time constraint is related to childcare? Or all right, now the last, this is a true story. This is not me giving a hypothetical. Well, not really the last thing. The other thing is I told you all to think about what Mr. ROTHENAY is charged with. Has everyone had a chance to think about that? All right, you may get some questions about whether or not you will be able to this nature. Here's the thing. In order for us to have a jury, guess what? We need jurors. So if it's not something that's going to damage your psyche or you can't make a decision because of the charge, that's different. But just because you're uncomfortable by it, we need jurors. Does everyone understand? All right, so here's a true story. My friend from law school, her name is Laura. She actually works in Austin now in this story. So she decided to go into, I always wanted to do criminal law. So I've been a defense attorney and a prosecutor. And she had jury duty. We hadn't seen each other for a while because she's doing civil, they work extra long hours, I'm working extra long hours. So one day she tells me for jury duty. And she says, let's do lunch. I'm like, this is great. We have. So we meet up for lunch and it's like old time. It's like time is past at all. And I said, how's jury duty going? She's like, I'm like, okay. I'm like, well, why did you say that? She's like, I'm not getting selected. I said, what do you mean you're not going to be on the jury? She's like, I'm at the back, staying quiet, not answering any questions. So I started laughing. She's like, what's so funny? I said, you are so getting selected. He's like, what? I said, yeah, for some reason, people who are always very quiet get selected. So other than raising your hand and saying, please, jury, if you remain silent, more likely than not, it's not the burden of proof here, you will end up on the jury. So with that being, I'm going to turn it over to the state. And then after the state does their selection, I'm going to give you a sharp break, and then we'll turn it over to the defense. State.
Thank you, Your Honor. Good morning, everybody. My name is Michelle Hayden. Today is actually my 12-year anniversary, which I'm celebrating with you guys. I grew up in Temple, Texas, went to school in Austin, and met my husband in San Antonio. We have 2 kids, and we're here to stay. The purpose of jury selection, as the judge mentioned, is to find 12 jurors that can be fair to both sides in the case. This is the during trial that we have the opportunity to speak with you. So if there's an issue we need to know about, if there's something that's going to prevent you from being fair and impartial, now. Juror number 23.
Yes. The only reason why I believe a parent was a detention officer, so I've heard many stories. it's kind of influenced the way I think, and especially the defendant. I personally, I will state that I feel like he would deserve.
Okay, so right now we're here on, you guys haven't heard anything, and what we're really asking of everybody in the room is to wait until you hear all the evidence before making a decision. So the judge talked about the presumptions, we'll get into that a little bit more later. Doesn't mean someone's actually innocent, they're just presumed innocent right now, you've not heard anything. So with that said, being in the courtroom, do you think just because we're here, he's guilty?
Is
All right, just one moment, please.
somewhat.
Do you think just because we're here not having heard any evidence that he's automatically guilty?
It's not 100% that he's guilty. I just have a lot of influence, outside influence, that would make me lean towards that. If I were in court, if I were to hear him out, I would be more hesitant to hear him out, if that makes sense. You know, I'm listening to him, but I'd be hearing, not listening to him.
Now, juror number 20, you can go ahead and sit down. Thank you. Juror number 29.
I work for child state.
Okay. And you have, again, haven't heard any evidence in the case. Not having known anything, you're gonna find one way or the other. Okay. All right. Thank you for letting us know. 57?
It's too close to home.
Okay.
I can't.
And if there's something pretty personal that you don't want to talk about with your,
No.
okay, 74 new best friends, we can talk to you about it at the end. Your number 38?
Also personal family experience.
Okay.
What number was that? What number was that?
38. Juror number 7? Okay. And we'll get into these questions a little bit more. Juror number 16?
My wife worked for a rate crisis. You're gonna have to repeat that last part. I'm actively the accuser.
Juror number 26?
It's also too close.
Okay. And we understand that everyone comes in here with their life experiences. All we're asking you to do in this two.
Personal, too close to home.
Okay. All right. The people that have said something personal, we'll call it at the end and talk to you. All we're asking you to do is wait until you hear the evidence, if you're actually called on the case, to determine whether or not the defendant is guilty or not guilty. Is there anyone here that can't do that? Can I get a show of hands? Okay. So I use this example. Anyone whose car that is? Yes. And this was actually about 12 years started at the office. I had gone back to my car after work and someone had in my CDs and I was not happy. Now as prosecutors, we do get called for jury selection. So if I've been called for a burglary vehicle case, then I would have been the best juror. Driving into work with no window. No. Now it's been so long, this was just a minor I could sit on a burglary vehicle case and be completely fair, I believe. But we just want to know if there's something like so mental, so fresh in your mind that it's going to make you incapable of being fair. The judge talked about a lot of times jurors think that if they're quiet, going to get selected for jury selection. The way it works is process of elimination. The people that let us know how they're feeling, we can get a good read on. Oftentimes those tend to be better for one side or the other. It's the ones that don't, that do tend to get selected for jury selection. So again, this is a bifurcated trial. Defendant, if found guilty, has elected to go to judge for punishment. So the only thing that you're here to determine if you're selected to be on the jury is whether or not accused of, if you did in fact do it. You're not going to get to hear about criminal history, any mitigation, any real influence on the victim, that sort of thing. That type of evidence. So your only question is whether or not we've proven our case, proven the elements of the case. Now, as the judge mentioned, if you're selected to be on the jury, you're not going to be here for the punishment phase. Now, did anyone say that they want that? Aside, okay, juror number 16, 47. Everyone else okay with that? All right, so the elements of the offense and what the state has to prove when we go forward on the case is on or about July 28, 2018, in County, Texas, this defendant intentionally or knowingly sexual contact by touching part of the genitals of a with the intent to arouse or gratify the sexual desire of any person. And the complainant, Angelina Straub, was under the age of 17. So intent to arouse or gratify, use your common sense. You know, if someone accidentally bumps up to you on the elevator and apologizes right away, or if you're changing a diaper, that sort of thing. And it's the intent to the sexual desire of any person. The defendant can be trying to arouse a third party. Everyone understand? All right, again, knowingly, that's the mental state in this case. Intention, you are selected to be on the jury. Don't think you've got to memorize all of this right now. I'm just breaking it down, but you will get the law before you go back and enter your deliberation. So intentionally basically means conscious objective or desire to cause a result, or really aware that conduct will cause the result. So again, we're not in the practice of prosecuting accidents. You're on a crowded bus and someone bumps up against you for a second. Yeah, not that sort of thing, intentionally or knowingly. Okay. So sexual conduct is defined as the touching through clothing of the anus, breast, part of the genitals of a child, or any touching of any part of the body, including through clothing with the anus, breast, or any part of another person. So it can be skin to skin, or it can be above the clothing. Does anyone have a problem with that? Does anyone think, well, if it's the clothing, we should be in felony court, we should be in misdemeanor court? Or it should be a different offense if it's skin to skin rather than there's clothing. Anyone? On or about, the law requires us to allege a date, but we're okay to put on or about. Sometimes with children, it's hard for them to remember exact dates. Does anyone here have kids? Juror number 6, are your kids, how old are your kids? 20. Okay, so they're fine with it now. Do you remember when they were real little? The concepts of time or? So I have a 3- and 4-year-old, and about happened yesterday, or everything that's about to happen is tomorrow. When I see my parents, which are 2 hours away, they ask how long it's going to be, and I say the length of a barn yard. They're just not very good at keeping time in their head. So what we have to prove is that it happened on a certain date, but really it's just prior to the indictment limitations. And in this type of case, there's no statute of limitations. So the judge touched on this, but our burden is beyond a reason. Anyone want to tell me what that puzzle is a picture of? Juror number 15? Okay. One time I asked, what's this a picture of? And someone said a puzzle. And that's right, but I have to be careful how I write it down. And you know that's a gun. And are there pieces missing? Alright. So I kind of think of beyond a reasonable doubt, like this picture. It is not 100%. It's not beyond a shadow of a doubt. It's not beyond all doubt. There's no legal definition, but you have to use your common sense at arriving at your own definition. What would have had to happen for you to know something happened 100%? Be there, exactly. Juror number 14. And if you be able to sit on the jury in this case, well, you'd be a witness. So you'd probably be testifying. Okay. So does anyone have a burden? Does anyone say, you know, I'm here in felony court, I need to prove their case to me 100%. I need to have absolutely no doubt to convict someone. Anyone here feel that way? And it's okay. Again, there's no right or wrong answers. Okay, can I get a show of cards? Can you stand up? 28, 61, 63. You guys all need 100%.
Live with that on my conscience if I wasn't absolutely sure. If I was absolutely sure, ain't no problem, but I doubt.
Okay. And juror number 50.
I'm not too much for sure.
Okay. And that's fine. Okay, so everyone here knows that we're a station case. So what types of evidence?
Judge, I'm gonna object. Let me approach.
Okay.
Just one moment. Ladies and gentlemen of the jury, again, I just want to remind you that the state's voir dire and the defense's voir dire is not about this specific case. It's all in hypotheticals. Does everyone understand? All right, thank you. State your name, continue.
So the crime that we're here on is indecency with a child by contact. What type of evidence would you expect to hear or see in this type of case? Anyone? Juror number 16? Exactly. Anyone else? All right, thank you, Juror 14. Juror number 29?
Any type of video.
And do you think that someone committing this type of crime is likely to video?
It all depends. If there was there's video cameras all over the place.
Okay. What if someone were someplace else? Do you think it's something they're?
There could be a witness.
So juror number 16 discussed this, that witnesses are a favorite of evidence. A lot of times they think about videos or, in a murder case, you think about the weapon, that sort of thing, photographs. But witness testimony tends to be the primary piece of evidence. Witness testimony is evidence. So in a case, an indecency with a child case, who chooses? Who do you think selects who's present when the crime is being committed? Juror number 37?
Person that did it.
Exactly. So the state doesn't choose who the witnesses are. The victim doesn't choose who the witnesses are. It's the perpetrator. As the judge talked about, we have the one witness rule, which is the law in Texas. You can convict someone based on the testimony of only one credible witness. All the elements to you beyond a reasonable doubt. So I want to know if you heard from just one witness, his or her testimony proved all the elements beyond a reasonable doubt. Here is number one, I would still require additional evidence to find the defendant guilty. Or number two, I would be able to find the defendant guilty. So can I get a show of hands, who thinks more along the lines with response number one? And can you guys stand up so we can see? 22, 24, 27, 21, 28, 29, 2, 35, 51, 54, 57, 59, 60, 61, 72. Is that everybody who? Sorry. Number 10, 5, 12. Did I get everyone? 58. If you're selected to be on the job to judge the credibility of witnesses, how do you judge someone's credibility? Before?
I guess you have to check his background.
I'm sorry, juror number 4, if you can, we're gonna need you to stand so that Brenna can.
Well, I would say, but you have to check out the background of the defendant or whoever that girl guy was, and see what they've been, they've been doing stuff like that before. They're criminal.
Okay, and in these types of cases, a lot of times you're not going to hear about a prior criminal record. But if you're, thank you though.
Sure.
If you're sitting here and you're listening to someone testify, what sort of things are you looking at to see whether or not they're credible? Consistency, okay. Juror 57?
Your eyes, their face.
Okay, so body language,
Level of detail.
detail. And do you think that every time you tell somebody what happened, their story is going to be the exact same? And why is that?
We're human.
We're human, exactly. So the main thing is, when you tell a story or thinking about a memory, you may not remember every single detail. You may not remember what color shoes you were wearing. You may not remember what you had for breakfast, but you're going to remember the important events. If you were in a car crash or something. Who do you think a witness may be in an consumer child case? Juror 15? A parent. And does anyone else here have children? Okay. Do children ever tell lies?
It depends on what they're going to know. If they brush their teeth, yes. If they were sexual. I don't think so.
So themselves into trouble or uncomfortable situations. No. It sounds like you're saying they lie more and it's like, oh, did you clean your room? Or did you brush your teeth? Exactly. Another question, which do you believe is more common? Numbers, number 1 or number 2? A child completely false allegation about sexual abuse, or a child abused when they actually were? Can I get a show of hands with number 1? That's 34 and 40. You align with number 1? One thing I just want to bring side effect. Judge talked about those lawyer shows. This is not Hollywood. We don't have a blood spatter expert that we call in on our cases. We don't have dirt comparison. There's not DNA particles just floating around in the air. So a lot of times you're not going to see that sort of thing in these types or in many of our cases. Judge talked about the presumption of innocence. I want Allie to be able to speak to you for a few minutes, and you'll be happy to know that the judge has limited the amount of time we had for voir dire. So I know you guys are waiting this morning, but you're not going to be here all day for jury selection. So common issues, if a child is under 17, it doesn't matter whether it's consented. We do have exceptions. You know, if someone's within 3 years of age, say you've got a senior who's 8, sophomore who's 15, within 3 years, that's not something we're going to prosecute. But is a child always likely to scream? Okay. And why is that? Someone I haven't heard from. I appreciate the participation. Juror number 33. Exactly. I'm going to skip a few of these slides. So yeah, who's most likely to be an abuser? A stranger on the street or someone close to home? Why is that? Okay. Has anyone here themselves or had someone close to them been the victim of indecency with contact or sex abuse? Can I get a show of numbers? 2, 7, 10, 16, 26, 27, 33, 37, 38, 49, 40.
Yeah.
Sorry. 41, 55, 57, 60, 61, 70, 72, 73, 75, 20. Has anyone here them or themselves been accused or charged with indecency or a crime? 21, 55, 2. Turn it over to Allie, but does anyone have any last issues they want to talk about before I sit down? Juror 24.
I just want to clarify that I heard you correctly. You guys don't get to choose the witness, it's just the defendant.
Well, who's present when a crime is committed? I should say that. Not who testifies, but who's there. So is someone more likely to commit a crime in a dark alley versus center court in a spur? That's what I mean. Juror number 71.
decency or just assault against a child?
I'm primarily talking about child sex abuse or indecent. All right, thank you for your time.
Yes.
So I'm gonna talk fast, guys, because I do a little before I run out of time. So I'm sorry. There's some, I just want to ask some specific questions. So juror number 10, you served on a grand jury before? Okay, how long ago was that? Was it a while? Okay. How was that experience for you? Is it gonna affect whether or not you can be a fair and impartial juror in this case?
No, because I don't even remember what it's.
Okay, good to know. You also served on a jury, correct?
Yes.
A criminal jury? How long ago? Was it here in Bear County? What kind of case? Do you recall? Was it a felony? Were there 12 of you or 6 of you? Okay, so it was a felony. Do you remember if you came to a verdict? Okay, did the punishment you had? Okay, it was the judge. Okay. Let's see. Then I have number 21. You're on a jury as a criminal jury. How long ago? 6 or 7 years ago. What kind of case? Capital murder? The judge or a jury?
The judge is.
Okay. That was nice. Let's see, juror number 31. Cross on a criminal jury. How long ago?
About 6 years.
Nuisance, what kind of case? Or 6 or 12 of you? 12, so it was a felony. Do you remember if you came to a verdict? 42. Where everybody is. And you were also on a criminal jury.
Yes.
What kind of case?
It was a felony case.
A felony case?
Yes,
And did you come to a verdict?
we did.
You did? Do you know if punishment went to a judge or a jury?
It was a judge.
The judge? Oh, thank you so much. There's a lot of former jurors. I'm skipping these civil. Then we have number 63. What kind of case were you on, sir?
It was an EWI.
Okay, so misdemeanor. Did it go to the judge or the jury? It sounds like it was the.
Well, I don't want to contaminate the jury, but I did have an issue of not being able,
Okay.
it would have, instead of taking all week, it would have been
Over. Yeah, it's just kind of one of the rules to protect and give defendants a fair shake. Is that you need to go in and try to judge just the crime before them and not judge the prior past. That makes sense to everybody. And that's the main reason you don't carry it. We don't want to take you guys. There's a few other people we have questions on for your conflicts, but we'll be able to get to you hopefully before I run out of time. If not, we will try to talk to you after. So there are a bunch of you that cards saying that you had some time conflicts. Now, keep in mind when the judge says that, she really is talking about something you cannot get out of. However, Michelle and I do not anticipate this case going past this week. I would be stunned if we were not done before Friday, but things happen, you never know. So just, you should not be here past this. Keep that in mind. Is there anybody who hearing that still has a conflict out of? Please raise your card. Number 10. Later, number 12. 38, 47, 21, 34, and 53. That is my time. And 37. That is my time. 44.
No, no, question.
Huh?
Sorry.
Yeah, no problem.
I believe the formula allows you to pick one or the other, civil or criminal.
Mhm.
But if you serve both, you can't pick both. So do you want to know if you serve criminal,
Yes.
assault, guilty, and I want to say the judge.
Was it here in Bear County? Thank you so much, 44. And thank you guys.
All right, everyone, right now I'm going to a short break. And if you all could be back lined up outside at 11, that'll give everyone a chance to get a break. So wait a minute, before everybody runs for, I'm gonna do a paper chase, and I know nobody's seen paper chase my age range, but look to your left and look to your right. These are people who should be standing in line with you. Make sure that everyone lines up and we're back by 11, because if we're not back by 11, we can't start unless everyone is here. And I'm gonna need everyone to leave together. All right, everyone, please rise. Yes. Remember, those are very expensive. All right, before I turn it over to the defense for, I just want to let you all know that you may see people coming for that door to speak to me. They actually should be coming through this door, but they have different papers for me to sign, and it's nothing related to this case. Even though we're in jury trial, I do still have a full docket, so I have other cases that are happening. So and it's not about this case, it's about another case. Does everyone understand? You are so great at raising the cards now. I appreciate that. All right, I'm going to turn it over to the defense for voir dire.
Ladies and gentlemen, I just want to see if I hate to do this, but I have to before we start. In Texas, we say voir dire. We don't say what. It just tells you she's not from around here. I could say that forever.
Yeah.
And we all give her a hard time about the Frenchification, what she talks about. So this is your opportunity to share your thoughts with us. How many people here have not answered a question or raised your card? Anybody? And I don't mean just for the general questions, for anything else. Okay, so who here has been to see the world? Okay, and I don't know if I've been there forever. I don't know if they still have Shamu. I think they got in trouble for that, but remember the splash, right? And if you had little kids, you wanted to sit in the splash zone. If you were old and crotchety like me, you don't want to sit in the splash zone because then you'd have like wet shorts. So unanswered questions are in the splash zone. Okay, like the judge said, if you don't share your opinion with us, then what happens is you sneak on the jury and you find yourself going, how did I end up here? Okay, so the important thing to realize is wrong answers. Okay, we're just trying to find out if you're the right for this kind of case. Maybe for another, there's something you want to talk about, or I tend to talk a lot. My wife tells me that. So if there's something you want to talk about or something that you want to bring to our attention, just raise your hand. Okay? Because there's sometimes things that need to be talked about that raised. And I can tell you, we've all been kind of shut down for 2 years, so we're all kind of honing our games again, trying to remember what the world shut down. Okay, so I get to make the state do most of the work. Okay, and they have all the technology, so I'm not very good at computers, so I had to have and I'm gonna low tech it even more with my fancy poster boards. Okay, but I want to follow up on some of the questions Michelle talked about. I want to ask you some separate questions. Who here can tell me why people lie? Who here has not answered a question and wants to answer this one? Okay, let's do number 34 first. Yes, sir.
For personal gain,
Like what?
they might be able to get something out of it.
So like for what?
So they'll lie for it. That's why they'll lie.
Okay, thank you. And number 40.
People lie because when you're born, you're not born below, and God lies, which is the devil. He rules, he's the prince of the air, he rules. So unless you have an encounter and learn about Jesus, we'll be a liar. And the devil is the father of all lies.
So do you think everybody lies?
Absolutely.
You think they lie?
Even Christians. Yes, I do.
Okay, all right, thank you, ma'am. And somebody else over here raised their card. Number 7, yes, ma'am. Okay. Have any thoughts about that? Okay, and next for number, what number are you? Okay.
Stand up, I can't hear
Yeah,
you.
if you could stand up, she's gotta take, nobody's trying to put you on the spot, but we have to make a record of all this, okay?
They try to fulfill what they wish was achieved.
Okay? Yes, number 21,
Some people lie because of code.
okay? And what, how would you ascertain that? What do you look for to see if somebody's lying?
Personally, I usually look at the body language, the eye contact,
Okay?
and the fact that they're the way they're speaking it, the way they're saying it.
Okay. Anybody else have any ideas? Juror number 9.
To protect someone they.
And somebody else was number 22. Yes, ma'am.
Yes, sometimes they lie because they're tricks people.
Okay. Who educate? That is, hey, we usually have about 20 people. Okay. What grade level do you teach?
I teach 3 to 2nd grade.
Okay. Kids lie?
Yes.
Okay. What do they normally lie about?
You know, if they knock paint over, or say, they'll say, we'll get a, we'll say, oh, so-and-so did it, but that kid was never even near that paint.
Okay.
So, no Wi-Fi.
Okay. Have you always taught the same grade level?
Yes, recently I started kinder to 2nd for the last 5 years.
Okay. 15, yes, ma'am. What grade level do you teach?
High school.
Okay, here in town. That's like the old San Antonio question, ask somebody where they went to high school, and we all kind of know about each other. Where do you teach?
I can't hear you or see you.
Yeah, if you could stand up, I'm sorry. Okay, and what classes do you teach?
High school math.
Well, I'm a lawyer. You ever have any kids lie to you?
Yes.
Okay. What do you look for? Parent, is it something you knew about, or could you tell by body language that you were being fed a story?
A little bit of both.
Okay.
Yes, I teach math, so
Okay.
different versions of the quiz or any test or obvious. But a lot of the year, I'm just gonna ask them about it. There's, okay, we'll talk and we'll tell by contact.
Okay. So when you say demeanor, what do you mean by demeanor?
And they're fidgety.
Okay, like they're on the spot. Yeah, the reason that my wife is teaches Our Lady of the Lake, and I guess now they have a software that you can feed it. Like somebody writes a paper, you can feed it into the software right away. It's like dangerous time to be a kid. Who else has any thoughts about body language, about what to look for? Who has not said anything yet? Okay, I want to give you an opportunity. Number 2. Come on in, water's fine.
Eye contact.
Okay. So like if they're not making eye contact, it can be an indication they're not being truthful.
Yes.
Okay. Juror number 4.
Well, all the kids are different. I can tell my kid, I have 2 kids and both of them, my son is big, but he doesn't lie. If he lies, I can obviously say when he's lying, he never does. But my daughter is 6 years old and she looks straight me in the eyes and lies. Like, I didn't do that.
How do you know she's lying? You will have seen her do it and then she.
Well, I know that she did it. I know she was the only person in the house, so, I mean, if I didn't do it, and I asked her, she says no, but I just know it because mothers, know what their kids are lying about.
Okay. So what do you look for in somebody else?
Like my son, if he wanted to tell a lie, I know he kind of like hides his face from me or tries to change the words, or like he kind of like he's being like nervous a little bit. I can tell that.
Okay, and juror number 5.
Their stories not consistent. Triple the words when they're trying to put the same. They don't know exactly what they're trying to say. And they know as they go.
Okay, yes, number 55.
I think sometimes it's defensive.
Okay,
Was probation officer for many years.
here in Bear County.
And I came across that a lot. Looking defensive, but it was an indication that we yes.
What unit did you work in?
I was actually stayed in county courts, but I was in the intensive supervision unit. For DWI.
How long ago did you leave the office?
Probably about 25 years ago.
Okay.
I don't know anybody there.
I don't know anywhere either. There's been a lot of turnover. So I'm gonna use my fancy boards now. Now, you're gonna be really impressed by my use of technology. And I've tried other ways to do it, but I'm not. Usually I have my son help me, and he's smart with computers. I'm not. So what I'm going to do is I'm going to go through. I have a series of questions. All I'm going to do is ask you for your number. Okay. So the first one is going to be, I would need a defendant to testify before I could determine. It's kind of like what the judge talked about. Okay. So it's either going to be between 1 and 7. If you're 1, you absolutely would need the defendant to testify before you could determine guilt and innocence, right? All people say, well, I'd like to hear from him. And the judge about it. So if you're a 7, you wouldn't need him at all. Some people, okay? So everyone understand what I'm asking? Okay. See this high-tech board right here? Okay, I want to be like they put up the letter. Okay, so what I'm going to do is go through. All I'm going to do is ask for your number. Okay, and you absolutely would need him to testify. If you're a 7, not at all, and you can be anywhere in between. Okay, everyone have a second to think about it. The people in the back, you're going to get to study the people in the front. Your answers are going to be easy. No cheating. Okay, juror number 1. Okay, juror number 2.
I just want to state defense.
Oh, that's hold on, I'm being corrected. So, yeah, okay. It's gonna get messy.
Just one moment.
Why the judge always better than me in law school. Okay, so to streamline the process, everyone had a chance to think about your answer and think about what your number is going to be. Okay, so if your answer is number 1, that you would absolutely need the defendant to testify, raise your card, please. Everyone ready? So it'd be number 5, number 7, number 16, number 19, 23, 37, 39, 51, 59, 57, 63, 65, and 72. Okay, so same question. Who here says their answer would be number 2? Still really one, just not quite as bad as the number 1 people. Okay. All right, everyone ready? So that's going to be juror number 2, number 8, 11, number 55, number 58, number 64, and 66. Okay, see, this is. Okay, now, same question. Who here is a number 3? Kind of sliding back down, not quite as necessary to have. Okay. Juror number 10. Number 21. Number 26. 27. 29. 30. 35. 50 and 61. Who here is a 4? Okay. Juror number 1, juror number 9, number 4, number 12, 13, 15, 17, 22, 25, 34, 42, 46, 53, 54, 49, 67, 70, and 71. Okay, now we're at 5s, right? Who here is a 5? Okay, juror number 3, juror number 6, juror number 36, juror number 38, number 48, juror number 60, 62, 69, 71, 73, 74, and 75. Okay, almost there. You have 6. Okay, that would be number 24, 28, 31, 41, 47, and 52. Okay, last one. Who here is a 7? You would not need the defense to testify. Period, exclamation point. Okay, it'd be number 20, number 30, number 33, number 40, number 40, 45, and 44. Okay, did we get everybody? Who here did not raise their card at all? Okay. We all heard, I talk about somebody getting off on a technicality. We all heard that. If you watch a crime, you've heard that, right? They got off on a technicality. Nobody ever defines technicality. Okay. So, the question is, and this is what I want you to think of. Same scale, 1 through 7. Too many obviously guilty persons escape punishment. Legal technicalities. Okay. And if you're 1, it's all the time. Okay. Right. And if you're 7, you're going to stay. Okay. Yes, sir.
I'd just like to clarify escape punishment.
Okay.
That in the perspective of ourselves, as far as the what we.
I'm talking about court punishment.
As far as
Well, yeah, I mean, like we're talking. You ever watch any crime shows? What do you watch?
I haven't seen anything in a while.
Somebody gets arrested, goes to trial like the next day. So what I'm talking about is in relationship to the court system. Like you watch on the news that so's case got dismissed, so there was a legal technicality, right? Avoid criminal conviction or punishment because of legal technicality. Okay. We all understand? Good to go? Okay. Who here is a number 1? Absolutely, that happens all the time. Okay. Number 11. Number 23. Number 30. Number 38. 47. and 62. Who here is a 2? That happens a lot, but okay, that would be number 15, 21, number 37, number 40, number 57, and 72. Okay, CR3s, please. Okay, be number 8, number 9, number 14, number 17, 19, 25, 26, 27, 28, 50, 51, 53, 54, and so you're 55, right? Okay. 65 and 66 is, I believe, the 4s, correct? Okay. If you lose track of that number count. Number 12, number 7, number 13, number 22, number 24, 31, 32, 35, 39, 45, 48, 49, 58, 59, 60, 64, 60, 67, 68, 69, 70, and 71. Okay, 5s. Juror number 2, juror number 10, juror number 4, juror number 5, juror number 6, number 29, 44, 46, 63, 73, 74, and 75. So the 6s, correct? Okay, anybody? Juror number 1, juror number 3, juror number 20, number 33, 34, 36, 41, 43, 52. Okay, 7s. Anybody? Okay. The one that I talked about was burden of proof, right? We've all heard the term beyond a reasonable doubt. Who here has never heard that term before? Okay, number 19. You don't watch crime shows. Okay. And if you could, we'll need you to answer out loud. Okay. So we used to be able to define it for you, but the legislature in its wisdom said we couldn't anymore because we have a really smart legislature. So essentially it is what you say it is. You determine whether or not the state has proven their case beyond a reasonable doubt. Okay. So one of the things I want us to think about, and I'd like to see a show of hands. Can tell me whether or not, as we see, Jeremy ROTHENAY is guilty or innocent. Anybody? Number 16. I understand that. I understand you told us that. Number 34. Yes, right. So that's the point, right? So as we sit here right now, nobody's heard any evidence, right? Our burden is on the state. Okay. I think I'm allowed to actually sleep during my part during the trial. I think that actually happened on a case when it's supposed to be. So, and state doesn't meet their burden, then that's it, right? They have to overcome this burden in order for a defendant to be convicted in the state of Texas, right? He's beyond a reasonable doubt. By the evidence they introduced in front. Okay, so there's different legal standards we have, right? The judge talked about some of the different standards we have, right? So guilty beyond a reasonable doubt, right? That's the threshold, not 100% doubt, because then you'd be a witness, right? Because if it's beyond all doubt, see what happened, okay? So then, any guilt beyond a reasonable doubt is not to convict somebody in the state of Texas.
Robert, can you turn it to me?
Oh, I'm sorry. Yeah.
Yeah.
So, strong belief in guilt, unless they've proven their case beyond a reasonable doubt, a strong belief in guilt is not enough. We understand that? Who here thinks that's enough for them? I know,
Your Honor,
I know, we're good.
I'm gonna object to the diagram. I don't want the jury to think that those are legal definitions.
Oh, I'm not saying the legal definitions at all.
That'll be overruled.
So, anybody else feel the same, that, you know, if I listen, I kind of feel like it's guilty, or I think somebody's guilty. Is that enough for you? Who here thinks that's enough to convict? Okay, can you be fair? Can you stand up and try to? She has to take down what you're saying.
Well, I mean, the experiences that I've had, it was really hard for me to do.
And I think we're going to talk to you about that up front. I know a lot of people have some personal issues, and I certainly don't want to put anybody on the spot.
I just don't think you would be fair for him.
We understand. That's what we're going to call you up. I appreciate that. That's where we talk about, sometimes there's different types of jury people may want to be on, right? The other one I wanted to talk about, and the judge touched on this, is anybody have anything they want to ask me about? Any questions? Or went to high school, what I like to eat? Anything you want to, who here has still not answered a question? Number 17, jump on in. What do you want to tell us?
Ask you a question.
Sure, or say anything. 28 years in May. Sometimes I feel like I'm serving a sentence.
Have these masks since the pandemic been a different, since you can't see their face or anything?
Generally, I object if witnesses testify while wearing a mask because you can't see their expressions. So that's always been an issue, but we've been Zooming for, well, counties have been out in trial for a year. Dare County, this is my third trial in Dare County in 9 months, and it used to be about once a month. All right, so let's go back to number 17. So are you number 18, right? 17. So what do you think about the burden of proof?
Robert,
Yes,
can you
ma'am.
not stand in front
Oh,
of
I'm sure.
the ability to make a decision that, like, all of the evidence and all that, make that decision. That's what it needs to be done.
Okay, so let me ask you a question. So I'm sure some of the people who got jury duty here before know, being a jury can be kind of pressure packed, right? Are you a person of conviction? Do you think you can stand by your convictions if you were selected to be on a jury? Thank you. Who else? Anybody else has not spoken? Answer any questions. Juror number 39.
Yeah, so I get to see a lot of the that side of the
Which media company?
San Antonio television.
Okay.
See the investigations that from other all kinds of background stuff that nobody knows.
Okay, so how does it make you feel about potentially being a jury?
Still be biased,
Be fair. Okay,
even though I don't see a lot of it.
okay, well, you probably see the good end of that. Right? Anybody else? Yes, number 41.
I'm a foster parent. I've had some children in my home that have had. Sometimes they say they did it, that it happened, sometimes they say it didn't happen, so.
Okay, all right, thank you, ma'am, I appreciate it. One last question. Your number, was it 20, you're 24, right, ma'am? Okay. You had indicated that you don't think children ever lie about allegations like this, correct?
Yeah, I believe children about sexual assault, yes.
Okay. Is that a blanket policy, or, I mean, are you willing to usually, or is that just something that's gonna sit in your mind, and if the child says that, you're gonna believe them no matter what? Okay. Anybody else feel the same way? Who here thinks children allegations like that?
Jack, that's not what she said, Judge.
Oh, okay.
All right, that'll be over. You can ask your question. please.
Okay. So who here do not lie about allegations like this? Okay, so it would be number 4, 7, 2, 16, 15, 26, 3, 37, 38, 39, 29, 47, 57, 61, 62, 67, 71, 3, and 75.
65.
Oh, 50 and 65.
Yes.
Okay, so I'm gonna go through people who just raised your card on this.
Sorry.
Yes,
The question is tricky because it's not so. I would doubt that a child says it happened when it didn't so much as I would doubt that a child says it doesn't happen when it did happen. So it's like the reverse kind of lie.
oh,
They
you,
lie about it when
okay,
it didn't.
okay, okay.
That's my.
Which means that you're saying that they could have found one.
Yes.
So are you saying that the lie would only go one way?
Not necessarily, but having been around children who have been in the circumstances, they tend to lie more about it not happening to protect
When you say children in the circumstances, what do you mean by that? Is that professionally? Professionally? You said children in the
In a
circumstances.
couple of cases, yes. Because I work in medicine.
Okay. And where do you work?
I work for BAMC.
How many cases like this have you worked at BAMC?
It at BAMC,
Or anywhere?
none, but in the 20 years that I've done this, we've come across 3 or 4 patients that are questionable where we have to call Child Protective Services.
Okay, all right, so you can either believe, and I think she makes a valid point about the lie goes one way or doesn't go the other way. So I want to go through and talk who raised their card. Juror number 4, correct? I'm sorry, juror number 2, you raised your card, correct, ma'am?
Yes.
So, if you believe that words like this, would that affect your impartial on a case like this? Would you give, children don't lie about this? Are you saying you would automatically testify?
By personal experience, I would.
Okay. All right. So, say number 4.
So I'm not saying never, child never lie. Or most likely they will, I would believe them. But it has to be like a couple of sessions to, I don't know how, something, but you have to listen to, I personally, a kid doesn't have a background of these things, most likely. Make up a story like this.
Yeah, so we can't tell you any of the facts, right? So the only question is, are you going to give extra credibility to a child because of a viewpoint that children don't make these stories up?
Yes.
And then juror number 7.
Yeah. It happened to me.
We can talk about it in front of the.
No, I'm fine.
Okay.
The thing is, the truth, I even told a younger cousin just to warn her, my uncle. And that cousin told her that, and my mother made me lie to her, saying that didn't happen.
Would that experience make it so partial on a case like this?
Pretty much, because I do believe it doesn't.
Okay.
Period.
Thank you.
It's going off my.
I appreciate your honesty. Juror number 9.
Yeah, I didn't point, but I was a school nurse for 8 years and 4 of them. So I think it would very much depend on the age of the child, how I would feel. If it was a smaller child, then I would believe the child. If it was a teenager, I would listen to circumstances.
So what you're telling me is you can wait, listen to the evidence, and then make your decision. Is that right?
Yes.
Me, school. And my wife says all her students like to teach elementary school because their kids are easier. And then they hit puberty and it goes crazy.
Middle school is.
Okay, so you're saying that you can wait and hear the evidence in a jury. And let me talk about the other thing. If it's testifying, are you saying you're automatically going to believe?
Yes.
Okay. You're number 9. Yes, ma'am.
I do believe it, like, when she says that you're sick.
Okay.
I wouldn't be this, I would be fair enough to listen to the trial or in a couple of sessions that we talk to the children. But I mean, when I would believe 100% the child, and it does depend on the age.
Tell you the age.
No, not the age. I mean, it, to me, it depends on like in middle school or high school, they can make up for, because they have a flashback of what these things are going on, but not a child.
Okay, well, so tell me what, I hate that, I'm gonna go. So what age, let me go back to you, number 9. What age are we looking? You say, I start, I mean, what do they do? Middle school here is not. Okay, so what's the cutoff for when you start, or when you stop believing them and think they may lie? Okay. Hard and fast?
No,
Mature?
that's all of it.
Okay, a lot of different factors. Right? Okay. Juror number 15. Same question.
I think I would,
Here, can you stand up?
I think I would give it to the child.
Okay. And I guess you say you would give the benefit of the child. You would believe the child just because she's a child. Her answer was yes. Okay, number 16. You got your answer. Juror number 23. Okay. So most likely, are you going to give a benefit of the doubt to a child testifying just because they're a child?
Yes, I would believe it.
Okay. And juror number 26.
I would probably say that because of personal experiences, and I feel that as a parent should be there for your child when the child is calling out for help.
Okay. So do you think your personal experiences would make it so you right juror on a case like this, you can be fair and impartial? Let's see, juror number 29.
Robert?
Okay.
Thank you.
No. Okay, I'm about to sit down, make everybody happy. Obviously, people are happiest when I leave. Anybody have any other questions, anything you want to ask us about? Cowboys fan? Those fans, please. Yes, number 24.
I just want to guess at how much longer this is gonna be.
This process, the trial itself.
This day.
I'll answer that.
It depends on, well, I guess whether or not you're selected. And I always tell people, my day depends on the judge wants me.
All right, what I can tell everybody is this day is going to last until finished. As I told everyone before, your country only asks one thing of you. Asks you to vote You can vote or not vote. That's completely up to you. They know ask you to go to a draft, and my uncle was drafted, and he at an age where he had to get permission. So every of Grand Canyon, Louisiana, all the young men were being drafted. And so my grandmother signed for my uncle to go to Vietnam War. The time that we're spending here in jury selection and all your country is really requiring is show up to be selected. This is a small amount of time in everyone's life. And so this process, which everyone who wants a jury trial is entitled to have one, this will take as long as this process takes. All right.
Judge, she has another question.
Yes.
I just want to clarify. Well, I just wanted to get a sense because I think a lot of us have to arrange after things.
All right, is there anything else, Mr. Mauer?
No, that's it for now.
All right, thank you.
Thank you,
All right, I'm
Dr.
gonna
Day.
need everyone to step out in the hallway. The people who are sitting in the jury box, make sure that one, you leave your numbers, and everyone leave your, and the people in the jury box, make sure you take all of your personal items with you. So if y'all can wait in the hallway, and then some of you may be called back.
Okay, yeah, that's good.
All right, ladies and gentlemen, there's just a few more questions from the state and the defense. State.
Okay, hi, guys. So since you've just had a bunch of stuff thrown at you for the past hour, a few things we wanted to clarify, based on some answers that y'all gave, okay? So I'm gonna kind of start by everybody. I believe you're all sitting in order. So the big thing I want to talk about real fast, and I'm just gonna do it as a group, go through and get your individual answer. When the judge talked in her part of about the one witness rule, most of you didn't raise your hand saying you had a problem with it. It was only when Michelle went through and asked like the number 1 or the number 2, and you guys raised your hands saying, I would need more. So I want to just kind of talk so briefly about what the one witness rule is, just to reiterate, and then kind of get your answer after you've thought about it. The one witness rule, say I'm being robbed. I'm by myself, someone walks up, points a gun at me, takes my wallet off. No one else is around, the security camera's out. I am the only witness. I am the only witness to say, this is what happened, this is what the person looked like, that's kind of why we have something like the one witness rule. So keeping that kind of in mind. If I came in and I was the only witness to the crime, there might be the officer I gave my story to, who tried to find the video, but they couldn't find it, check this out. I'm not necessarily going to be the only witness at my trial, but I am the only one who saw it. Everybody get that? Okay. So keeping that in mind and kind of hypothetical, what we are asking for you is if you get on the jury, sit and listen to the evidence fairly and impartially. And if there is one witness who you find credible, who you believe beyond reasonable doubt, and just their testimony alone to what the offense is, makes you believe beyond a reasonable doubt this offense occurred, all we are asking is that you can say, yes, guilty. There may be, but they're not necessarily witnesses to the crime, but you just have to, and I can think and use my common sense. And if they tell each and every element, and they have proven to my definition beyond a reasonable doubt, I can hold them guilty. Everybody got that? So now that I've kind of talked about it a little more, I'm going to see if everybody followed. So number 4, would you be able to follow the one witness rule? Yes. Number 5.
Yes.
Number, you're not sure, right? 12. Yes. 12. Yes. 22. 22. Yes. 24.
Okay, so I understood what the judge said, and that makes you said, and that makes perfect sense. But then when you asked one of the potential jury people, they said that it was only the defendant that could, and not the state.
No, so what she meant by that is, so my robbery description, the only person who decides who's witnessing a crime is the person who robs me. The person who says, I'm gonna look around, here's this woman, she's walking through a parking garage by herself, there's no one around, and I choose to go do it. That's what we mean by he chooses who the witnesses are. So I am the sole eyewitness to the actual crime. He doesn't determine who I go and talk to, like who investigates and stuff like that. That's what we meant, not necessarily who we're calling it. Make more sense now?
Yes.
Okay. Okay, so can you follow? Okay, and then number 24? 27, sorry. Yes. Yeah. Yes. Okay, and then 28, I also have a quick question for you.
Well,
You,
I'm sorry, New York State. Could you continue with your
Sure.
one witness?
Yes,
Then you can
welcome
go
back.
into other.
let's see, then number back here we have 29? Yes, okay, and then 32? Yes. 35? 51? Yes. Sorry, you're all moved around, so I'm double checking numbers. 58? Okay, 59? Or 59? 60? Yes. And 72? Yes. And then, just briefly, and this is just for you, When Michelle was talking about the burden of proof being reasonable doubt, meaning that it is basically up to you, common sense. Look at it, say, do I have a doubt? Is it a doubt? And is it to something that the prosecution has to prove? If it's like, he was wearing, that's not one of the elements we have to prove. But would you require 100% no doubt?
In my mind. And 100% the same thing.
Okay, so you would require just 100%. Thank you, that's all I have for this group.
All right, defense.
Judge, I don't have any questions about the home witness rule, but I just want to. If I have them on.
1 second.
Do you want them?
Yes, please.
If I have. What are the? Juror number 4. And if anybody else answered to the same question about whether or not you believe children don't make these stories, you would indicate that originally, right? Okay, can you answer louder, please? Because yes. Did anybody else give the same answer? Okay, juror 27. Okay. And
That was juror 20.
okay, okay.
Depends on the age.
Okay, yeah, I think somebody said that. So I guess the question for juror number 4 is, would that your belief that children don't lie, make it so you couldn't be fair and partial to my client?
No, be fair.
most likely.
Okay, so, well, I guess that's the question, so. If you believe that children stories up, right? Okay, then can we agree that you're probably not the best juror for a case like this, right? Because that you're kind of, you've tilted the playing against Michael, right? So, agree that because of your beliefs, you couldn't be fair and impartial. Okay, well, I guess we try to pin you down. Okay, maybe it doesn't really work, maybe it doesn't work. So, in fact, you believe that children don't lie in these circumstances. Are you gonna more likely than not believe the child? Are you gonna say, hey, it's a child, children don't lie, and that's how you believe, right? Okay, so does that mean you're leaning in favor of the state before the trial starts? Okay, well, you're saying that you don't believe children make up stories like this. So without having heard any evidence, right? You haven't heard any, okay. Would you agree that you decided what the outcome is?
I still have to hear the story. Most likely, I will believe it.
So if the child testifies, right?
And mind you, this is a hypothetical.
Yeah, right. I can't tell you anything.
Yes.
Is your, well, I don't believe children lie, so therefore that child is not lying. Okay. And would you agree that you're probably not the best juror to sit on a case like this? And that it would not be fair to my client. I'm not saying, we all have thoughts and notions about, like the judge said, she shouldn't be, or Michelle Ricardo. Somebody broke the window. She agreed that she would not be the best kind of juror. Right? Yes. So would you agree, because of your thoughts, you would not be the right kind of juror for a case like this? And then number 27, I think you had raised some issues. Would you feel more comfortable with the bench, or are you okay talking? Okay, so you had, did you answer the same question about, I know we had talked about children lying, right? Do me a favor, can you?
Yes.
Are you okay? Okay. So you had indicated part of your job was cases like this, right? Or not investigating, you had worked on cases like this.
Well, I've had patients come into the clinic with questionable finding. I work for this, so you can have a child come in with crabs or ice or bruises and things like that. So you have to bring behaviors to a doctor's attention, because I, technician, cannot make any judgment. I have to say what goes on aside from my and how parent parties act.
Your experience would incline you lean in favor of the state. Okay. Do you think you can be fair and partial on this?
I have a hard time saying yes or no. I can see where a 16-year-old could look like a 3-year-old with good makeup, and you can get into a situation not knowing and have been lied to, versus a 4-year-old saying something happened.
Yeah, like I said, we can't.
And that's the hard part. So I think I could be fair if I knew the story, but if you ask me now, I couldn't give you like
you didn't indicate, you didn't answer yes when he asked about children never making up allegations, right? Do you think children ever make that? Because I asked that question about children.
I said I lean more towards the other direction when it comes towards guilt, where they would say, no, something happened.
So do you think you can be fair and impartial in the case?
Yes.
I know it's not a question, why answer. And somebody else, anybody else have any answers or anything else they wanted to? I think we've already solved your problem, sir. Yeah, I think we're good to go. I think that's.
All right, thank you. All right, ladies and gentlemen, the jury, if you'll just go. No, 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 no. Do not take that. That's very expensive.
Okay.
All right. We have reads for the group that was just called in and Brenna, we're on the record.
Okay.
Well, just for the record, but we forgot about that and he somehow wound up in here.
Oh, yeah.
That's true.
Yeah.
You're right.
Not with Judge Barton, it's not.
All right. Defense's motion to strike number. And then number 59, you all agreed to.
Yes, Judge.
All right, anyone? You have still some members left on your
We do for the conflict, but if we're not gonna deal with the conflict, then that's fine with us.
Okay, then we'll move on to defense.
So Judge.
Just one moment, let me go through the list. 2. 4 is already gone. You have 7.
7's gone, Judge.
8. 9. 11. 15. 23. 28.
28.
Thank you. 29 is gone, is that correct?
Correct.
Then you have Oh. Ladies and gentlemen, the state and the defense have a few more questions for you. Defense. We
What are the numbers we're doing on the witness room?
It is 8, 19, 37, 51, 55, 64, 66, and 72.
Thank you. Yeah.
Juror number 11. If you could wait outside for us, thank you. Some exercise on the Fitbit. All right, defense, you can start.
Okay, so we had talked about during board diary, we talked about it at night as well, about the Fifth Amendment side. And y'all had indicated that you wanted to hear from the right? So y'all agree? Okay, so and obviously the judge has told you, and we'll tell you what on a jury, the entire burden rests on the state. No defendant is required to testify. And the law is you can't hold it against them. Now that's how the law applies. Okay. But we all have personal beliefs. So there's no wrong answers here. Obviously, what we're trying to find out is you're the right kind of person to sit on this. So what I want to find out from you is your belief that the defendant needs to testify something that you can't. Okay. And if you can't, that's fine. It's all we need is on stage. Okay. But I'm sorry, what number you see? Juror number 8. Could you render, say the state puts their case in, okay? And you're like, I don't really believe it, okay? That's like not beyond a reasonable doubt. Okay. But would your belief that the defendant needs to testify be such that you're gonna like, man, he didn't testify, he must be guilty?
I mean, usually that was like if people are not guilty, they tend to speak on it. They don't just keep quiet about it. So I'm used to that aspect of it.
Why somebody might not get on the stage testimony. What about other issues? I mean, maybe the speech medical issue. Okay, so the big question is your belief going to make it so you cannot be fair and impartial? So if the state doesn't prove their case, right? Say the state finishes, and I don't do anything, right? Sit there, read a book, play some video games on my phone. And if the state finishes their, I don't think that's the verdict. Is that enough? Okay, and that's even if my to testify.
It's their job.
Okay. So you think you can be fair and impartial? And I'm sorry, what number? You were number what? And what number are you, sir? 37, okay, same question. You needed to hear from the defendant, or you wanted to hear from the defendant? Okay, and if the defendant doesn't testify, are you consider that in your deliberations? Like if you're on the jury, even if you're not supposed to consider somebody not testifying, are you going to go back there and say, listen, he didn't testify today? Okay.
So here's the thing, everyone needs to speak up. There's no need to whisper. This big question is that you all realize someone who's accused of a crime and brought to court, they have a right to remain silent. Does everyone understand that? Now, sometimes people would say, I wonder what they would have said. It's okay to do that. You cannot hold it against him or her or whomever it may be. Does everyone understand? So the question is, if someone chooses not to testify at trial and they're accused, hold it against them. Defense?
Okay. So your answer, what number are you? 37. Okay. And what, I'm sorry, what number are you, sir? 19. Number 9. And the judge uses the term hold it against the defendant, but if is the defendant's testimony something you have to hear in order to render a verdict? Okay. And so if the defendant doesn't testify, you're going to pursue that he's guilty. So you would agree that you could be fair and impartial on the case. Is that correct? Okay. And I'm sorry, what number?
38.
38. Same question for you.
I just have a hard time understanding why someone wouldn't take the opportunity to defend themselves if accused. I mean, I certainly would. That's my internal. Take the opportunity to save my innocence.
Okay. You know where the nobody's required to prove their innocence, right?
I understand that.
The state's, the burden's entirely.
Yeah. Okay. I still understand why. Quite frankly, if you're capable, if you tell me someone's not capable.
Okay. Well, you understand we can't tell you.
No, I understand. Hypothetically, if you told me someone's capable, then that would carry my decision. But I fail to understand why someone wouldn't. Frankly, I understand the law.
Okay. Understanding the law. If you're on the jury, and this is the law you have to follow, right? Is your belief that you just talked about something that's going to weigh my client or any defendant who doesn't testify? If you're accused of something, you should get up there and testify.
Yeah.
Okay.
Yes.
And so that would not be fair and impartial.
Definitely not, but it's, I mean, it is what it is.
I appreciate the candor.
Rationally speaking, I can't say everything I want.
No. I told you, whenever we come in here, I mean, the term I use is prejudice, but in the term that we all have beliefs and thoughts, and all we want to do is find out what yours are. All we're not trying to do, nobody's casting doubts or aspersions on anybody, we're just trying to pick your brain. This is the only chance we have to do.
Yeah.
You're 30.
Right.
Then you, sir, number
51.
51. Okay. Okay. So if we have a and the defendant doesn't testify, right? It's talking about, everyone has a right to remain silent, the burden is on the state. Well, let's so you put your selected on the jury there, and you're like, yeah, you really should testify because I have some questions, but he didn't testify. If he didn't testify, he's probably guilty. Right? You understand?
Right.
So the question is, if you're picked on the jury and you go back there, are you gonna take that lack of testimony from my client or any defendant into consideration when you deliberate? And that's something that will weigh on your mind or affect your decision making there.
Yes.
Okay. And then you worked at the probation department, right? Okay, so same.
I would like to hear from the defendant. No.
Okay. If you're selected, would you hold the state to their burden? Okay, so if the state didn't meet their burden, even if the defendant testify, you can still find somebody not guilty. Okay. Your number
64.
64.
You have to go the other gentleman up here. There's two sides there. Sure, I'd have to hear both sides.
Okay. Okay, so unless you heard from the defendant, you could render a not guilty verdict. So if you change.
Yes.
Okay, that even if the state, even if you had questions about the state's case. For number 72, same question.
For me, it's contextual. So the first part would be that the nation seems to have a lack of witnesses. So it would be difficult to triangulate the truth from both sides.
Okay. Well, so the determination you make as a juror is whether or not somebody's guilty beyond a reasonable doubt, right? So I guess really the question is if you hear the state's case and you don't think they've proven their case, could you still find somebody not guilty even if the defendant has to testify?
What concerns me is that the state makes it on the case and doesn't testify. It's close.
Okay, so, but we can't tell you any of the facts. What you find the court is that you would consider a defendant's lack of testifying when you're deliberating on the case, even if instructed not to. And you're number 72? Juror number 66. Okay, same question. Okay, so, well, let me a question from the other way. So if the defendant, say the defendant doesn't testify, say you listen to the state's case and you're like, I don't think they met the burden. At that point in time, game, set, match, right? If the state hasn't met their burden once they finish, that's the defendant's not guilty, right? Well, if the state finished their case, that they met their burden, and the defendant didn't testify, could you go back and deliberate guilty verdict because the state didn't meet their burden?
I didn't hear.
So say we have a trial, like say you're on the jury, okay, and the state finishes their witnesses, okay? And I don't run any evidence, okay? If you don't believe the state's questions about the state's case, right? You don't think they met their burden. For you, or you gonna consider the fact that a client or any defendant didn't testify when you're back there deliberating, right? Are you gonna go back there and say, well, listen, I don't think they met their burden, and there must be something to it, or you would testify. What way would you see it? So would the fact that it didn't speak be something you would consider? Would you think about it? Or would that enter into your deliberation? Okay, well, I'm harp on you, I'm just trying to pin you down. to an answer. If we have a trial, and the state, you don't think the state has met at that point in time, you don't hear any other evidence. Is that enough for you to find somebody not guilty, or you can consider the fact that they didn't testify in the deliberation? You would, okay, yes, you would consider the fact that they didn't testify in your deliberation. Okay. And when you say consider it, so when you're deliberating, you're gonna say, hey, this guy didn't testify, and therefore there's something to this, where there's smoke, there's fire, I don't, you know. Okay. I don't have any questions.
All right, anything from the state?
Just to clarify, at verse 6, I know you're kind of getting past multiple. So it's one of the, all have kind of like unconscious things in our lives, you know, bias always play a part. So it's just like, in this case, you could kind of wonder what they would have said. But what he's basically asking is, despite your or like, I mean, I would like to hear it, that you can listen to the evidence, and if you don't feel that we've met our burden of proof, you can hey, he didn't testify, would have been nice to hear from him, but I can set that aside and render the not guilty verdict. Can you do that? Okay. It would enter your mind, it would not be something that would factor in to your decision. Not we've done our job. Thank you. No further questions, Judge.
All right, thank you. Step outside for me, please. Schedule this for 2:30. No, let me know the schedule that for 2:30. All right, so everyone.
Oh, Judge Thomas.
Yes. So, with regards to the jurors, any agreements?
I'd agree at strike 6. You shouldn't be
Oh,
allowed to,
you're- Right.
you shouldn't be allowed to sit on a jury.
Have a problem with that.
Okay, 66 is agreed to.
That hurt.
All right. Any other agreements?
19.
Who's the one that said he never heard of beyond a reasonable doubt ever?
Yeah. I was
Oh, yeah.
like, no, sir.
Okay, all right, so agreed.
He should go party with number 4.
Oh. All right, so is agreed. All right, let's go in order. So number 8,
No motions from the state judge.
Not for me either.
11,
That's agreed, judge.
number 19 is agreed. 37,
Yeah, Judge, that's a defense was strike for cause. He said he would hold it against my client, or they said they would hold it against my client.
We're fine with that.
all right, that'll be granted. Number 38,
Same thing, Judge.
that'll be granted. Number 51,
I actually have no motions on it.
all right. And 64,
Same thing, Judge.
granted. Six, you agreed to.
Yes, Judge.
72,
Same thing, Judge.
all right, then that leaves the other people you want called back. 15.
I also have. Do you guys have 9?
I did have 9. somewhere on
Which-
here.
which
Yes,
one? I have
9.
9 as-
Yes,
yeah,
okay,
as-
someone don't want.
Yeah.
All right, so 2, 9, 20, 23, 33, 39. 51.
Yes.
Okay, make sure that's on my list.
51 was struck, yes.
Yes.
He does for 50 for children lie, or children don't lie.
Geologist, number 51.
I think we did agree to 51, didn't we?
No, oh no, wait, 51. Wait.
Okay.
Because I was,
Yeah.
I did not have 51. Okay, just one moment. So then it'll be 50, 51, 55, 60. 70, 70, 72, 73, 72 is done.
Yes.
I have 2, 9, 15, 20, 23, 33, 30, 51, 55, 60, 70, 71, and 73. Deputy Laura, could you bring in jurors number 2, 9, 15, 20, 23, 33, 39, 50, 51, 55, 60, 71, and 73. Everyone, if y'all could just move directly into your question.
More questions here, you guys are on this one.
I think this.
Yeah.
All right, thank you. All right, bye-bye. Yeah, I know. We're gonna be starting at 2:30 for the 2, so we have lunch break. I think that girl may need some WD-40. Sounds like it. All right, everyone. The state and defense have questions for each of you. Be sure to remember to speak up. It's okay to speak loud in here because we want to make sure that Brenda is writing everything down. Well, not writing, but again.
It's right.
All right, thank you. All right, defense.
Just wait 1 second, please.
Yes.
Some of these questions are gonna be delicate. And I don't think any of us want to be on the other's privacy. So if there's something that y'all would rather in private, please let anybody who'd rather do it that way. So one of the questions that the state had asked was about people who have friends, members who were victims of sex offenses, correct? And a couple we already asked other questions about, but who here raised your hand indicating that you had a friend or family member or personal involvement with sexual abuse? So you're juror number 2, correct? Can you tell me who it was? How long ago did that happen?
She was about 8 years old, but she's 30 now.
I can see. Would this case for you to be on?
All right, then you can move to the next.
And then, I'm sorry, your juror number 20. I guess we're talking at the bench. Okay. Was it? Can you tell us who it was? Whether it was a friend, a family member, or
Myself.
yourself? And was it when you were younger?
Yes.
How old were you? Let me ask.
Around 12.
Okay.
10, 13.
Was it?
Yes.
Okay. Is that would be something you carry with you back into the jury for selecting on the jury? So, okay. You don't think? Do you think that experience would affect your ability to be fair and impartial?
No.
Okay. So that side, and not consider that a no brainer. And I'm sorry, who else? What number are you?
30.
Okay. I guess same question. Here. Okay. So can you tell us who it was?
That was my
Okay. And how long is that?
7 years ago.
And did it involve a family member?
Yes.
And
Not anyone I know. Or
were you involved?
I did not testify. There was no my case that person like that.
Would that experience affect your ability to be fair?
I don't think so.
And do you think you can listen to the
Yes.
and then juror number 39? Okay, same question.
I had a friend of mine, her daughter was someone that was the person, she was already in the age of 16. This happened years ago.
Okay.
It was a family member. She moved herself and out of the state. Recently.
Experience be something that would affect your ability to be fair and impartial?
Not sure how to answer that.
Okay. Well, can you give it your best shot?
To be fair, yes.
Okay, well, the big issue is we didn't know not whether you think you could be fair, it's whether you actually could be fair. So experience is something that's going to weigh on your mind if you're deliberating, such that you should probably not, this should not be the kind of case that you're on.
To me, I feel that I can do the best to be fair.
Okay, so I need a hard and fast answer. Okay, I know you're saying you want to do your best to be fair, okay?
Right.
So the question is, could you be fair? Not could you do your best? We all want to is, could you be fair to my client? And if you can't, because of the type of case in your experience, there's no wrong answer.
Yeah, I can be fair. I can be fair.
Okay, and then judge the case based strictly on the evidence you
The
hear.
evidence.
All right. And then, I'm sorry. Let's see. I guess, who else raised their hand to this question? 55. Okay. So, who do you know, was it you, a friend or family member?
To the children of two very close friends, housing the children very well. Actually, quite emotional.
Okay.
Both.
How long ago was this?
They both went to trial. Trial maybe just before COVID. The other one was probably 3 years.
You said you described it as being very emotional. And is it something that if you were selected on a case like this?
I think it would weigh on my mind. But I understand sure is.
I guess.
I mean, if it triggered those emotions again, you know.
Well, I guess
seeing
that's
the
that.
evidence,
I guess that's the question. So you say it triggers those emotions, and the question is because of that emotional experience, your friend's kids, would those emotions being triggered affect your ability to be fair and impartial? Because the entire question here is, yeah.
I think I could be fair.
Okay.
Yeah, I'm back to that.
Right, because the
Yes,
issue is.
I would be.
Okay. Well, this is a really important issue for me and for my client. Okay. We all bring our life experiences with us when we walk into this place. So you seem to have had some other traumatic experiences that have affected you, right? And so the question is, you've had such an emotional experience, and one of those just recently. Would those emotional experiences affect your decision-making process on this case? And listen, there's no one who's gonna get mad at you.
No, Possible. That's my answer. Possible.
Okay, you're just not sure. Thank you, I appreciate your hand. Yes, ma'am, what number are you?
Number 60.
Okay. Are you comfortable talking? Like group chat?
Well, it was me and my brother. And I also have a cousin that's doing time for decent exposure to a black.
Okay, so you had experience in both?
Yes.
Okay.
And I've reported anytime as being a teacher, educator, anytime I've suspected anything, I have reported it.
Okay. With those experiences, both yourself as a victim and who was charged, would that affect your ability to be fair and impartial in this case?
I believe some of the facts and the evidence, I go on what is shown in front of me. What my case was totally different, or, you know, like my brother, you know, when he went through it, he never said it until that person passed. So I mean, it's different, so I would not say, you know, if I went do it a certain way. That this situation is the same.
So you could judge this case with the evidence presented to you?
Yes.
Okay, thank you. I think, who else?
70.
Yes, ma'am. Same question, ma'am. You okay talking about that? Okay,
It was my sister.
okay.
It was a family member.
Um, affects your ability, but that situation with your sister affect your ability to be fair and impartial on this case? Let me follow up with another question.
Did you say no or yes?
She said no. Yeah, if you all could try to speak louder. You would also indicate earlier that you don't believe kids lie about allegations.
And I wanted to, number, I think it was juror number 9, and she kind of, when she was mentioning about the age of the children, it depends on that nature. I would think it, because I was in high school and I remember a girl lied about it. She said, her mad at stepdad. So I remember that as a teenager though, seeing experience.
So, I'd be a case by case basis.
It would be.
Okay. And I guess the same. I think it was when we were talking about what, yeah. What's the cutoff age? We can't give you an age.
Right. I wouldn't think like. Yeah,
Right, it kind of really.
Yeah, 10 and then
That's case by case.
Well, we can't give you any facts, right? So I guess the question is, not knowing the facts about the case or anybody who might testify, if somebody testifies, are you going to believe them just because they're a certain age? An age that you think is the one that's not.
No, I would also go by the evidence.
Right, so it's like the 10-year-old cutoff is kind of, the term used also is fungible, right? It's just kind of, there's no hard and fast rules, right? Is that right?
That's correct.
Correct to say that? Okay. Juror number 73, right?
Correct.
Okay, I guess, are you okay talking about it right now?
Yes.
Okay,
It was myself and my.
Okay.
Was the family member.
and how long ago did this happen?
40 years ago.
Something that still affects you today?
No.
Something you can set aside if you were picked on this jury? Could you judge the case based strictly on?
Absolutely.
Thank you. And then I had, I think we had a couple talked about, I think juror number 9. Okay. I think we talked about this situation about kids, right? The same question about kids not lying.
And again, I think given this, I think I could be objective about it, but also know developmentally, little kids are less likely to make. And the older they are, the more.
You're in middle school.
Actually, I was a school nurse from elementary all the way through pediatric nursing.
Would you agree that kids are a lot more sophisticated? Particularly with Advent iPhone. Right. Yeah, me too. It's a scary time right now. So if you're picked to be on this jury, could you listen to the evidence and that of a child, no matter what the age, and judge it based, you can use life experience, right, but judge it based upon the evidence you hear and not make any predetermined. Okay, and I think we had a couple other people with juror number 15, right? I think we had the same discussion, right? So what do you think about what juror number 9 said?
I honestly would give them the benefit of the doubt. I had a lot of kids reach out for help, and in my mind, if they're reaching out, then there's something wrong.
All right, and would that experience affect your ability to return?
The kid in this case, I would give them the benefit of the doubt that I feel like they would not reach out.
All right, thank you, ma'am. And I think I had a couple others. I think juror number 50. Yes, sir. I think you had indicated the same thing, right? Children that lie.
Okay, so I had a question actually.
Okay. You got to sorry. You want to ask the question anyway?
It was just, I guess, more along the lines of just the range of what a child is for age, I guess. So this is the young to 18, that's that kind of range of child. I mean, to the point what they're talking about is, yeah, I feel like as well as you get to lie, that person gaining your younger child. So, I guess for years that doing they might choose good for it, which say your morals, I guess, are really great. So, pretty much stuff is, well, it's right wrong. As far as and kind of as you get older, I guess the line sets in more, but as you're younger, the fact that goes on.
So is there an age, like we had the conversation about.
I'm gonna object to the question about a specific age. I think it's an improper commitment.
All right, here's the question. This is a case, hypothetically, indecency with a child by contact. So it's involving a child. Does everybody understand? Hypothetically, and I'm speaking in hypotheticals. The question is, if a child were to testify, in any case, no matter what age, will you base your decision on guilty or not guilty based upon the evidence that you hear? Is there anyone who would not be able to do that? All right. And what's your number? Number 15. Now, here's the question. Witnesses are usually called to testify in jury trials. Sometimes it may be a police officer, sometimes it may be a doctor, sometimes it may be a layperson, it may be a judge, it may be an attorney. The question, when you listen to those persons testify, even if it's a child, you won't have some preconceived idea by saying it doesn't matter who's testifying. If they're a child, I'm always going to believe them. Does everybody understand? This is what the question is and the issue is. Whether or not, if a child were called to testify, could you listen to that with an open mind and judge that child's or that person's credibility based upon what you're hearing from stand, not based upon a preconceived notion that maybe all children tell the truth, or maybe all officers tell the truth, or all doctors tell the truth? Is there anyone who won't be able to do that? And it's okay if you can't do that. The defense and the state need to know.
Yeah. Next follow-up question. You're number 23, right? And you had indicated, I think, on a couple different questions, that I think you would believe the victim above all, right? So, go ahead.
I said yes, because I didn't know she had.
Okay. Well, if you want to, I think you had told us that you believe these stories. You don't think kids lie, right? And you would start off in favor of the state or against the right. Am I misspeaking?
I just trying to decipher the words that I'm not used to hearing.
Okay, okay. Well, just some of you, in your words, what you had, I know on a couple different questions, you, I think you were right involved in the conversation. Do you think you would be a good juror to sit on a case like this?
I believe so, because I know myself and I know that opinions would weigh heavily on my thought process. similar to like what she was saying, like, or 15, I would be more, I would believe the kid more, and I would kind of, what I touched on earlier about having outside influence, that would kind of be in my head, and I would definitely have more of the benefit.
Okay, when you say outside influence, what do you mean?
That or a parent was a detention officer, so I heard a lot of stories and how people, what people say situations and how they're very avid, especially in cases like these, and kind of like it streams an emotion.
Okay, so would you that because you could be fair and impartial, that this is probably not the right kind of case.
Yeah.
Thank you, Madam Bishop. I think that's all I have.
Anything from the state?
Nothing from the state judge.
All right, thank you. Please. Yeah. State and defense.
Judge, we would agree.
Okay.
2023-55.
I'd
say 15.
2.
2 and 23.
Wait, slow down.
Sorry.
Yes. So, number 2.
Number 2, we agree. 15, we agree.
Number 9.
No, Judge. We have
Defense, number 9.
Oh, no, I'm good with her.
Number 20.
nothing.
Yeah, that move to strike for cause.
He explicitly said he could be fair and impartial judge and decide.
All right, defense strike for cause will be denied.
We'll agree to 23. Yeah.
33.
No motions from the state judge.
Let me find my copious notes.
I think, yes, said she could be fair.
Yeah.
Yeah, I'm okay.
39.
39 to be fair.
Yeah. He's the one with the friends.
Yeah, the friend's daughter. Number 55, the first one. Yeah, the local media guy.
Oh, yeah, I'm okay with it.
Okay, 50.
Nothing on 50.
The one
That got called back here because he had a question.
I can only take one at a time.
Sorry.
All right, so number 50. All right, 51.
Didn't speak this time around.
I don't have anything for.
He's the one who had said before the defendant must testify.
Mm.
I moved to strike for cause.
We would say when we called him back earlier, Judge, he said that he could. Said that he was fine with it.
All right, I'll grant defense's motion. Number 50.
Nothing from the state judge.
55 was, he said, he was talking about it. He said he was not sure if he could be fair and not sure his deliberations. I moved to strike for cause.
60.
60, they'd be fair, Judge. They had no problems. It was, she's been a big and a defendant, and she said that she would have no problem being fair.
Defense.
I'm okay with it.
Okay. 70.
There was also the juror's sister. She said that she could be fair.
Fine, I don't have any objections.
71.
I don't have any objections. So
73.
Also said that they could be completely fair.
I have no objections.
All right, so the record can be clear. The jurors that were agreed on, number 2 is agreed to. Number 4, defense strike for cause. Number 11 is agreed to. 15, 16 agreed to. Number 18 is agreed that they could be excused
Mhm.
because that was the person having a heart attack.
Mhm.
Number 19 agreed to. 21 agreed to. 23 agreed to. 28 agreed to. 29 agreed to. 38 defense strikes for cause were granted. 40. 51 defense strike for cause. 55 defendants strike for cause granted.
Sorry, which number?
Number. Yes. 56, it was agreed. Them, they stated they had COVID symptoms. Number 57, 58, and 59 are agreed to. Number 61 is agreed to. 63 is agreed to. 64 defensive strike is granted. 65 agreed to. 66 agreed to. 72 defendants strike for cause granted. 75 is agreed to.
That's what I have. Same here.
Defense, is that what you have?
Yes.
All right, we can go off the record if, please. All right, the jury are number 1, 12, 13, 14, 25, 27, 32, 33, 35, 41, and 42, and 44. The alternates are 48 and 40. Action state.
No, Your Honor.
Defense.
No, Your Honor.
All right, let's bring yours in.
Let's just tell.
I'll make sure you have a break.
Oh, okay. Thank you.
You're welcome.
No, that's not your fault.
Sit anywhere, but I'm just trying to. Sit anywhere? Anywhere.
Oh.
There's 3 chairs. Doesn't matter who's there. Anywhere. Anywhere. Anywhere there's room. If you're right here, there's space there. Right here. If you're in a chair, you just have to stand. Space is gonna be. Forward, 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 forward. You have to make sure everybody's safe.
All right, everyone, please be seated. All right, ladies and gentlemen, thank you so much for your service today. I'm going to call the names of the people who will be on the jury. For those of you who are not selected, you can decide if you wish to. We can send you back down to be selected and placed on another jury. Let it marinate. Don't immediately say, yes, I want to do that, because if you do, send you down. All right. When I call your name, if you'll take a seat in the box, please. Roberto Cumpian. Betty Alpawan. Justin. Frank Hartfield. Berta Genosa. Cole Morris. Karen Stein. Rachel Fair. Elisa Chavez. Christine Pilgrim. Sandra M. Arambura. Nathan A. Tony Vicencio. And I'm sorry, this person, your first name was cut off on the list, but it's Rodriguez Amperin. All right, ladies and gentlemen, what will end up happening is you all who are not selected, you will receive the little card that shows, or the, awesome. So here, you can get your parking validated downstairs in the basement, so you have to the central jury room, they will do that. They do allow you to donate your time because you get paid for your time here today, and I know it's not a lot, but it's enough for lunch. So what you can do is either you can accept that, and at some point this year you receive money in the form of a check, you'll be surprised, or either you can donate that. They have that you can donate that to in the basement. All you have to do is check a box that you want it donated, and they do have different organizations, so you can choose which organization you would like that amount donated to. So if questions, you all may leave and enjoy the thank you. Bye. Have a great rest of your day. Enjoy the sunshine. So everyone here, I'm going to give you instructions because I know you probably need for appointments. All right. So what's going to end up happening is that you all are going to be shown where you need to show up in the morning time. Deputy Laura is going to take you where you will be meeting up each morning. So each morning, you're not going to immediately come into this courtroom. You're going to come to our jury room. As you can tell, the temperature in here, sometimes it's cold. Sometimes people think I have control of the thermostat, and I'm just choosing to make people suffer and not use it. But I have zero control over the thermostat. If I were to turn it, it doesn't work. I think there's some central location what the temperature should be. But sometimes you'll come in the courtroom, it's freezing cold, so it's probably best for you to bring a jacket. Easier to take the jacket off and not have something. I know the chairs can be hard. We pillows to add for comfort. So if you need that, just let us know. The other thing is, as you can tell, sometimes we go late. If anyone needs to be excused or you need a break, just raise your hand. Either I or the defense of the state will see it, or the deputies, and they'll let me know. Brenda may even see it because I swear she has eyes in the back of her head. So just raise your hand. We're going to start each morning at 9 a.m. But we cannot start unless everyone is here. So if there's one person who's not here at 9, we can't start. Understand? All right. Any questions about anything?
Email their text as to where we're supposed to go.
Oh, the deputy is going to show you. Go. Okay. So every morning from here on out, you don't go to the central, up to the 4th floor, but you're not going to come specifically to the 187th District Court. Does everyone understand? All right. Any other questions? I thought you had your hand raised.
Every single day, I work nights. I'm a nurse, so I work 12 hours.
All right. Okay. Any other questions? All right. So you don't know this case. I don't expect this case to be in the news. I don't expect for it to be on any type of media or in the newspaper. However, if you do hear someone speaking, you need to move away. If you do see something on the news, on television, you need to turn it off. Does everyone understand? You are not to talk with each other about this case or talk to other people about this case. I will let you know when it's time for you to deliberate or talk with each other and come to verdict. Does everyone understand? So, and no investigation into anything. Everything that you need for this case will happen inside this courtroom. Does everyone understand? All right, so I will see you all tomorrow at 9 a.m. I do try to have us recess by 4:30. I do that because I know rush hour traffic is 5, and if you get out of here by 4:30, you'll miss the rush hour traffic. To that, maybe if we're in the middle of a witness testimony, but otherwise, I try to make sure that everyone's out by 4:30, okay? Yes.
Did you think that this might end by the end of the week, or could?
It's more likely than not, it will probably end before this week is out. Okay. All right, if there's nothing else, Deputy Laura, you need to be, and I'll see everyone at 9. Yes, muted. Place it on mute. It's mute. Put it on mute. On mute. All right, who's here for Joe Hernandez?
That's me, Your Honor, Nathan Slimane.
All right, is the state ready?
Yes, Your Honor.
Court is 2021 CR 11710, State of Texas versus Joe Hernandez. Can I have parties announced for the record for the state?
Joe Ray Garcia.
For the
Nathan
defense?
Slimane for Mr. Hernandez.
And are you? I need you to speak up.
Hey, can you hear me?
Yes, speak up. Are you?
Yes, ma'am.
We're proceeding by video because of the pandemic. Objection from the state?
Oh, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Hernandez, I'm showing you what's entitled Defendant's Consent to Appear Conference. Did you review that document with your attorney? Did you understand it? And did you electronic?
Yes, ma'am, Your Honor, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement, all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find in compliance with discovery. Mr. Hernandez, I'm going to show you what's entitled True Will of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am, I did.
Sorry,
Yes, ma'am, Your Honor, I did.
counsel, do you waive the reading of the indictment?
We waive it, Your Honor.
State, are you proceeding on the indictment as presented?
We are proceeding on count 1 and waiving count 2 and the repeater enhancement on the indictment.
State, I'm sorry, objection to waivers of count 2 and the enhancement objection.
No objections from the defense, Your Honor.
And the enhancement allegation. All right, this day, but it's still a beautiful Tuesday. Mr. Hernandez, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonition. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor, I did.
Did you understand in count 2, I'm sorry, in count with assault on a peace officer, judge bodily injury, that's a second degree range of punishment is anywhere from 2 to 20 years in prison and up to fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement, bargain for the fact that you enter a plea will not be used against you and you will be allowed to withdraw.
Yes, ma'am, I understand it.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state remain silent? I'm sorry, what?
Yes, ma'am, I do know that.
Did you understand by bargain agreement you were giving up those rights?
Yes, Your Honor.
And did you enter into a plea bargain agreement in this case?
Yes, Your Honor.
So has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
I believe he has a rational as well as a factual understanding of the charges against him.
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time?
In my opinion, yes, Your Honor.
Mr. Hernandez, has anyone threatened you, place you in fear to get you to enter this plea?
No, ma'am, Your Honor, sure, no one else.
Has anyone promised you anything other than the plea bargain agreement to get you to enter the plea?
No, ma'am, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor, I did.
Court
Yes, I did.
agreement punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. State is proceeding on count 1 and waiving the repeat enhancement allegation. There are no applications for community supervision or deferred adjudication. Did you understand that to be the plea bargain agreement?
Yes, ma'am, Your Honor, I did.
Defense, was that the plea bargain agreement?
That's the agreement as we understood it, Your Honor.
Plea bargain agreement.
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, Your Honor, I did.
Both places.
Yes, ma'am.
Did you understand signing that you're waiving your right to appeal? The only items that can be appealed are written motions and filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor, I did. I do
So were
understand.
there any such motions?
No, Your Honor.
Then to the offenses charged in plea, guilty, not guilty, or no contest.
No contest.
Is to support the defendant's plea.
State offers State's Exhibit 1 and its attachments.
Any
We have
objection?
no objections, Your Honor.
What's entitled waiver and consent to stipulation of testimony and stipulations. Did you, with your attorney, did you understand it? Did you electronically sign it and all the appropriate?
Yes, Your Honor, I understood it and I did sign it.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence of the witnesses' statements and police? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor, I do.
All right, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
We are, Your Honor. We'll waive PSI.
Mr. Say on behalf of your client.
No, Your Honor, other than respectfully would request that the court honor the agreement entered into with the state.
All right, the court will sentence you to 3 years in the prison. There's a $1,500 fine, time and money to run concurrent. Court will give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it or did you sign it?
Yes, Your Honor, I did. And I did.
Because this is a plea bargaining agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor, I understand.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor, I understand.
If you have a question over what a weapon or ammunition, is, you need to speak with an attorney. Do you understand?
Yes, Your Honor.
All right, Mr. Hernandez, good luck to you. Don't be the person who's at the Bexar County Jail in and out. You understand?
Yes, Your Honor, I understand.
All right, do better. And what is that tattoo you have? Was that painful?
Which one?
Oh, you have many. The
Yeah,
one
yeah.
on your chest, is that was that very painful?
Yes, yes, it was. The worst ones were in my head. You can't see the ones on top of my head, but around my chest area, those were the worst ones.
And as you're getting the painful one on the top of your head, at some point, do you say, this is too painful, I'm gonna stop, or you just push through?
Nah, you just push through, you know, it's not that bad. Pain's temporary.
Okay.
But
All right.
the work's gotta be good, because if the work's no good, then it's really not worth it at all.
Okay. All right. Have a great rest of your day, Mr. Hernandez.
Okay, you too, Your Honor. Thank you.
Bye. No more Mr.
Thank you, Mr. Hernandez.
Thank you, Mr. Swain.
Thank you, Judge. Take care. Joe, do you need to talk to me?
No, sir, I think that's about it.
Okay. All right. Best of luck to you then. Thank you, Your Honor.
You too.
Thank you,
for
Joe.
your time. Thank you.
Bye. All right. For the people who are on John Robert Gar, I did not have the discovery acknowledgement. Does anyone have?
Judge,
that?
I've been waiting for the state to send it to me. I thought this morning they were
Ron,
going
it was done weeks ago. I'll forward it to both you guys right now.
Oh, okay. If you'll
Yeah.
do that.
All
appreciate it.
right. Thank you.
I sent it to Lupe.
I thought you were in trial.
I am.
You
But now I'm
won.
here.
All right, and then-
You already won, huh?
And Charles Brown, have you had contact with Mr. Carroll?
Yes, Judge, I've been in continuous contact. He was, this morning,
He was about to park when y'all told us to come back at 2. So I told him not to park and I sent him home. And then when I met with Norma, I misunderstood that. And so my client's about to log on to the Zoom right now.
Okay, all right, we'll wait for him to zoom in.
He might be in the waiting room. I don't know if he is yet or not, but he's coming.
Okay, he's not in the waiting room.
Okay, I'll get him there. Thank you.
All right.
Okay, right down. You're gonna go.
Let me see. Print.
Sandoval.
Oh, that same girl that was here before. What her name?
Did she come here?
Her one?
Huh? Oh yeah, same girl.
Mhm.
Her cell phone number is. Huh?
Hey, Judge, Loopy, I show that it was already submitted and it's been,
Text her when you're on your way.
copy's already been returned to me.
All right. Now, Michelle just sent it to the court, so we're printing that out and we'll take that matter up. Is that possible?
Okay.
While you're waiting.
Judge, I was gonna jump in for Michelle. This is Ryan. I think you stopped my
Okay.
video though, Judge.
Oh, no, because I don't think you knew that we were live streaming, but nothing was happening just that. So. All right.
Okay, there we go.
All right, court is calling 2021 CR 10249, State of Texas, thank you, versus John Robert Garcia. Could I have parties announced for the record for the state?
Ryan Groomer for the state of Texas.
Ron Ross will respond to the defendant.
And are you Mr. John Garcia?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, ma'am.
None from the state, Your Honor.
Any defense?
No objections from defense.
Mr. Garcia, show you what's entitled defendant's consent to appear by video conference. Did you document with your attorney? Did you understand it and did you electronically sign it?
Yes, ma'am. Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented. Next, I'm showing you what's entitled application for deferred adjudication. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
For acknowledgement, have you received all the discovery in this case and did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with this. Mr. Garcia, I'm showing you what's entitled true bill of indictment. Did you review that document? Understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do, Judge.
State, are you proceeding on the indictment as presented?
I believe so, Judge. There's nothing, there's no counts or anything. I think it's just a 1-count indictment.
Mr. Garcia, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with is aggravated assault with a second-degree felony? The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am, I did.
If you have the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you enter a plea will not be used against you. Draw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right for your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
I didn't hear you.
Yes. Yes, ma'am.
All right. And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand that the court would grant your application for deferred adjudication for any reason your deferred adjudication were revoked? The court would find you guilty and sentence you up to $10,000 fine. Did you understand?
Excuse me.
I said, did you understand if your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison, $1,000 fine? Did you understand?
Yes, ma'am.
Counsel, has I've been able to provide you with any defenses to this offense.
He has, Judge.
He has a rational as well as a factual understanding of charges against him.
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter the plea?
No, ma'am.
Are you satisfied with the way you've been representing?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
The defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you the plea bargain page. As you review that page with your attorney, did you understand it?
Yes, ma'am.
Bargain agreement punishments be assessed at a cap of 6 years. There's a $1,500 fine. State will remain silent on your application. There's an affirmative fine and no contact with Michael Lopez. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
An affirmative finding of family violence, you're not allowed to be designated as primary custodial parent.
Yes, ma'am.
Did you understand that to be of your plea bargain agreement?
Excuse me, ma'am, I didn't hear you again, I'm sorry.
Did you understand that to be the entirety of your plea bargain agreement?
I didn't know that, but I do that.
Did you understand that's your plea bargain agreement?
Oh, yes, ma'am.
All right, then there's nothing, you understand that that is the agreement.
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, it is, Judge.
State, is that the plea bargain agreement?
It is, Judge.
Next, I'm showing you the paragraph, appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you actually sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such?
No, Your Honor, there have not been any filed.
Next, I'm showing you outside the agreement, the state is requesting a TAP evaluation. Recommendations from the state, and the court does not have to follow those recommendations.
Yes, ma'am.
Then to the offense as charged in the indictment, how do you plead? Guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
Yes, Judge. At this time, the state would offer State's Exhibit number 1 and all attachments to the court.
Any objection?
Judge, the only thing is on the stipulations where it says I confess, I admit and confess.
I don't be having time like that, dog. Real talk. I'm gonna go backwards again today, my nigga. I can't stand this bitch ass shit, my nigga. Real talk, I go kill that nigga, dog.
Sorry, Judge. Mr. Carroll made it. Joshua, mute yourself.
Nah, man.
All right. Yes.
Again, on the stipulations, the part where he admits and confesses that he did so-and-so, he's pled no contest. And he was wanting to have that changed, that I plead no contest, that I did such and such and such and such, instead of admit and confess. And we were unable to do that because of the way it's printed out on the.
All right, any objections to the court changing that it says, do not contest instead of hereby judicially confess and admit state?
State has no objection to that, Judge. We spoke to Mr. Ross and the defendant. I have no objection to that change.
And any objections to the court changing that the allegations are true and correct to that the allegations are not contested?
No objections from defense.
All right, any other objections to State's Exhibits 1 and
Other than that, there are no objections.
All right, Mr. Garcia, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review the document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you, attorney, to cross-examine and confront any witnesses the state will call on the right to remain silent?
Yes, ma'am. Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witness reports? But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived the stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1, review the same. All right, after reviewing the attachments, the court will find there is sufficient evidence to find you guilty. However, the court guilt as you apply for deferred adjudication. Are there any issues or what's going on, Mr. Ross?
What's
Does he
going
need to
on?
have Evaluation?
You're gonna have a pre-sentence investigation report done, correct?
Yes. So tap evaluation.
In the tap, yes.
Mr. Garcia, do you have any mental health issues in your family, or have you had any mental health issues or been diagnosed?
No, ma'am.
Okay. With regards to the tap, have you used drugs in the past?
No, ma'am.
All right, Ms. Reyes, then we're gonna do evaluation. I'm gonna request that. Ms. Ferguson, in the chat box, if I could have sentencing, please.
I'm sorry, Judge, you broke up. Was that PSI and TAP?
No, just a tap evaluation.
Just the TAP. Okay, thank you.
He says he's never used drugs in the past, so I don't know why we're doing a tap, but okay. It's been, and we're gonna come back on April 26th for sentencing. Mr. Ross, do you anticipate having any witnesses?
He may have a couple of short witnesses, character witnesses.
All right, let's put that at 2 p.m. then on April.
Okay, 2 p.m. on April 26th, correct?
Yes, 2 p.m. on April 26th.
Thank you, ma'am.
Thank you.
Thanks, Judge.
All right, you're welcome, Mr. Garcia. I'm gonna send you to a breakout room. And no one go to a breakout room unless I sign you.
Well, could you sign me to a breakout room with Mr. Garcia before we leave?
Yes, I am. I'm gonna send you all to breakout room number 1. Okay, who's unsettled? All right. Is that prosecutor available for settle?
Marcus is coming, Judge.
All right, thank you.
Judge, do you want me to stay in here? Do you want me to go to the breakout room?
Let's do this and then I'll send them both to the breakout room.
Okay, thank you.
All right. 2021 CR 10660, State of Texas versus Allison Settle. Can I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
William Davidson for the defense.
And are you Miss Settle? You're on mute.
Yes,
Are you
Your
Miss Settle? We're proceeding by video because of the pandemic. Any objection from the state
No objection.
defense?
No, Your Honor.
Settle, telling you what's entitled defendant's consent to appear by video conference. Did you review that document with your attorney? And did you electronically sign it?
Yes, Your Honor.
It's knowingly and voluntarily consented to appear by video. Next, I'm showing you what's in motion to revoke community supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Allison Lee Settle who was placed on community supervision in 2021 CR 10660 for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams on January 19, 2020, 4 years? Is that you?
Yes, Your Honor.
State?
Condition number 5, in Bear County, Texas, the defendant Allison Lee Settle did then and there fail to report to the supervision officer as directed for the month of February 2022 in violation of condition number 5.
How do you plead to that, true or not true?
True, Your Honor.
We'll waive the others.
Any objections to the state's waivers?
No, Your Honor.
Ms. Settle, did you understand by pleading true to violation of condition number 5, true, grant the motion, sentence you to 4 years in prison and $1,000 fee? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation number 5?
Yes, Your Honor.
Court will find violation of condition number 5 true. Is there agreement?
Yes, Judge, we are asking that you deny the motion, alter and amend to order a TAP evaluation and that she follow the recommendations of the TAP, a drug patch for 5 months, ELM for 90 days, the CATS 1 and 2 course. And we have agreed to TIC County Court 662207.
Wait a minute. I'm sorry, TIC what?
County Court case number 662207.
And what did you say with regard?
I'm sorry, Judge, you cut out.
What did you say with regards to the ELM?
ELM for 90 days.
Defense, is that the agreement?
Yes, Your Honor.
All right, Ms. Settle, can you raise your right hand for me, please? Solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God.
Yes.
All right, you can lower your hand. I'm gonna need you to speak up. For some reason, everybody is whispering. I know that when people are with their friends, they don't whisper. None of us here are in the CIA, at least I don't think we are. So none of us are spies. We can speak up.
Yes, Your Honor.
So I sent you to felony drug court. Why are you back here?
I have a reason I'd like to explain to you. It's not an excuse, but I've been in and out of the hospital with COVID. I'm 8 months pregnant and I messed up. I don't know.
No, that's not telling me anything. That's telling me telling me why you are here and not in felony drug court.
Right. I just wasn't able to keep up with my probation officer, and I have plans. I was like in the process of getting everything set up to speak to probation and get my blood drawn and everything that I had stipulated already.
No. I'm not talking about your DNA test. I'm talking about felony drug court. So why are you here instead of being in felony?
I don't know.
Can someone tell me why she's here and not in felony drug court?
Your Honor, I just know that once she got sentenced, that was the end of it. After that, I couldn't contact her and she never reported to probation. So she got sentenced and that was the end of it.
All right, so we're back to this point, Ms. Sell. Why are you not in felony drug court?
I don't know.
Right now, Ms. Reyes, why is she not in felony drug?
They rejected her because they were unable to contact her, and her references were no good, and so they rejected her for unsuccessful contact.
All right, and off the record, did you have a chance to speak with Mr. Garcia?
Oh, yes.
Rebecca?
I'm sorry?
All right, Ms. Ferguson, I need Mr. Garcia to come back so Ms. Reyes can speak with him. All right, so this is what the court is gonna do. I'm gonna deny the motion, alternate and conditions. She's to do the TAP while in custody. She is gonna be re-referred to the drug court while in custody. And then cats 1 and 2, and I'm assuming she stole something. State,
I'm sorry, Judge, you cut out again, so I missed the end of it.
cats 1 and 2, I'm assuming it's because she stole something.
Yes, Judge.
What were you stealing?
I'm sorry?
What were you stealing? What were you taking without permission or attempting to take without permission?
I think this was like 2 years ago. I'm not sure what it was. I think it was from Walmart.
All right. So we're gonna deny the motion, alter the main conditions to do a TAP evaluation while in custody. Cats 1 and 2, take in consideration County Court cause number 662207. Referral to felony drug court while in custody.
I have a question.
I accept it to felony drug court. Then is there an inpatient treatment facility that will accept her while she's pregnant?
I don't think so, Judge.
Right, well, she's not accepted into felony drug court, let me know and we'll come back and we'll. look into it. All right, Ms. Ferguson, can you do a thing for Ms. Settle? Sometimes in 2 weeks, please. All right, we're gonna come back on April 11th, Mr. Davidson. That's just to see if she's been transferred.
Okay.
And Rebecca, if accepts her, do not release her from the jail until she. Yes.
I'm sorry, Judge.
We'll do GPS. Once if she's accepted into felony drug court, she's gonna be on GPS. And then felony drug court, if they want to remove it, they can remove it. And we'll waive fees. And the GPS is for medical appointments.
Yes, ma'am.
Can I just get a clarification as to how long she's going to be in custody?
Yes, she's going to remain in custody while she's doing the detention. She's going to remain in custody while she's being evaluated for felony drug court. If felony drug court does not accept her, then we're going to come back on April 11th and figure something else out.
Okay, thank you.
All right, thank you. All right, I'm going to send you to number 1, Mr. Davidson. You can go to number 1 as well. All right, and then on Mr. Carroll.
Yes, Judge, I believe he's present now, as he made it known inadvertently.
Well, I mean, you say that, but I don't see him anywhere on the screen.
I figured y'all took him out of the meeting when he started talking. I figured y'all moved him back to the breakout room or something.
Yes, and he left the breakout room.
Okay, let me get him
Well,
back.
I put him in the waiting room.
Okay, let me find him.
Okay. Brenda, it's been
At least you saw him.
a strange Tuesday.
Do you need to see him again, or was that enough?
Yeah, if I could see him again. Charles, you added the smile so I could say, no, I don't see him yet. But yes, I
always
need to
smile,
see
Judge.
him.
I always
Yeah.
smile. It's my best attribute. That and my eyes.
Yeah, okay.
I'm reaching out to him right now.
All right, thank you.
Thank you.
Yeah, I guess we have a problem with Wi-Fi. He's calling them.
Oh, there's Garcia.
All right, Mr. Garcia, I'm going to send you to breakout room number 1. Yeah, Garcia just disappeared again.
The air went off or something. All right, all right. I know.
Hey. We know that. Charles, my understanding is that your case is set for gonna be June 28th.
I'm sorry, I didn't hear what date you said, Judge. June 28th.
June 28th. That's
I'm-
what Norma told me. Is that correct?
Let me look at my handy dandy calendar. June the 28th, Joshua Carroll. Yes, ma'am.
We'll see
He's
you
trying,
then.
he's trying to log on. I just talked to him again.
Yeah, he's not in the waiting area or anything, so. All right, we'll see you then.
Okay, thank you all.
Thank
Have a
you.
nice day. Can I let him know to stop trying?
Yes,
Okay, thank you.
you're welcome. Have a great rest of your day.
Oh, you too. Bye-bye.
Bye-bye.
Sorry.
Oh, that's fine. No, you can do.
I'm taking it out right now and.
All right, Norma,
She, for a second, there she's frozen.
I'm frozen. Okay. Are
So
you?
it says
What if you-
your
what if you
internet connector
leave-
is on
what if you
it's
leave
popping
and
up
come
on
back?
the screen.
Oh, we can do this.
Yes, I'm